Washington, Reuters. The U.S. Supreme Court on Tuesday blocked a California law requiring clinics that counsel women against abortion to notify clients of the availability of abortions paid for by the state. Ruling violated the free speech rights of these Christian-based facilities. The Supreme Court legalized abortion in 1973, and while the broader issue of abortion rights was not at issue in the case, the 5-4 ruling represented a significant victory for abortion opponents who operate these kinds of clinics, called crisis pregnancy centers, around the country. The court trademark S5 conservative justices were in the majority in the ruling authored by Justice Clarence Thomas, with the 4 liberals dissenting. The justices endorsed the argument advanced by the clinics that the Democratic-backed law in the most populous U.S. state ran afoul of the Constitution. Trademark's First Amendment guarantee of free speech by forcing them to advertise for abortion in violation of their beliefs. California cannot co-opt the licensed facilities to deliver its message for it. Thomas wrote in his opinion. Crisis pregnancy centers have said they offer legitimate health services but that it is their mission to steer women with unplanned pregnancies away from abortion. President Donald Trump trademark's administration hailed the decision. U.S. Attorney General Jeff Sessions said, we are pleased that today trademark's decision protects Americans' trademark freedom of speech. Speakers should not be forced by their government to promote a message with which they disagree, and pro-life pregnancy centers in California should not be forced to advertise abortion and undermine the very reason they exist. There are roughly 2,700 crisis pregnancy centers in the United States, including around 200 in California, according to abortion rights advocates, vastly outnumbering abortion clinics. California officials said some of the centers mislead women by presenting themselves as full-service reproductive health care facilities, going so far as to resemble medical clinics, down to lab coats worn by staff. While the ruling could make it harder for Democratic states that may be inclined to crack down on these centers to impose regulations, the court trademark's endorsement of the free speech argument could help abortion rights advocates challenge laws in Republican-governed states imposing burdensome requirements on abortion clinics. The justices reversed a 2016 ruling by the San Francisco-based 9th U.S. Circuit Court of Appeals that refused to block the law because it likely did not violate free speech rights. California trademark's Reproductive Fact Act, passed by a Democratic-led legislature and signed by Democratic Governor Jerry Brown in 2015, required centers licensed by the state as family planning facilities to post or distribute notices that the state has programs offering free or low-cost birth control, prenatal care, and abortion services. The law also mandated unlicensed centers that may have no medical provider on staff to disclose that fact.